Okay, so now a section on judicial powers. The royal courts of justice were created at the end of the 12th century. And they were an emanation from the King's Council. And the previous system of itinerant justice, which had existed since the reign of William. So by 1189, we had got to a situation where there were separate royal courts of justice sitting in a certain place in Westminster. And not following the King's Council around the kingdom. We also had a system of assize courts held in towns around the country, based on a system of circuits. I think we've mentioned this before. So that the judges were appointed in London but would then travel around the circuit to sit and deal with the more serious cases. Under Magna Carta, the principle was established that the judges should know the law. So the king had an obligation to appoint judges knowledgeable in the law. And this is why historically the judges have always been appointed from amongst members of the legal professions, because they're supposed to know the law. And I mentioned the case of Prohibition del Roi already, which said that the king couldn't sit as a judge because he wasn't knowledgeable in the law. The function of the judiciary is to enforce the law against individuals, institutions, and the executive. The Lord Chief Justice manages the business of the court system, and represents the views of the judiciary to Parliament and the government. The Constitutional Reform Act of 2005 requires the Minister of Justice to uphold judicial independence. And under the same act, judges are appointed by an independent Judicial Appointments Commission. And they continue to hold office on good behaviour, not at pleasure of the monarch. So judges are now subject to a disciplinary procedure, and the judges of the superior courts can only be removed by a joint motion of the two houses of Parliament. We will see in a minute that the constitutional role of the courts, apart from declaring the law or interpreting legislation, so the constitutional role of the courts, apart from declaring the law and interpreting legislation, is to ensure that the rule of law is protected through robust procedures enabling the courts to prevent illegal or improper actions of government, authorities, and tribunals. We'll talk about that a little more in a minute. I'd like to turn now to substantive constitutional rights. So a new heading, substantive constitutional rights. Unless there's anything you want me to repeat from there. The first section of this brief chapter on substantive constitutional rights concerns the rule of law. The Constitutional Reform Act 2005 said that it did not affect the existing constitutional principle of the rule of law, but it does not define what is the rule of law. And it was Lord Bingham, B-I-N-G-H-A-M, Lord Bingham, who has authoritatively defined what are the rules that make up the rule of law. And it's necessary to go through the essential principles of the rule of law. And the first one, the essential principle, is that all persons and authorities, public or private, are bound by the law and entitled to its benefit. And that laws have to be publicly and prospectively, promulgated and publicly administered in the courts. You want me to repeat that? No? So, all persons and authorities, public or private, are bound by the law and entitled to its benefit. The laws should be publicly and prospectively promulgated and publicly administered by the courts. So that's the sort of what he calls the core principle, the essential principle. The second principle is that the law must be accessible and intelligible, clear and predictable. Now you're specialists in the law. Do you think that that principle is achieved in practice? I don't think anybody thinks that has been achieved in practice. The law is quite often completely unintelligible. But anyway, that's the same in every country in the world. And that's because probably lawyers and legislators are not sufficiently disciplined. But that's another problem. Third principle. Questions of rights and liabilities should be resolved by law and not discretion. Fourth principle, the laws of the land should apply equally to all. So the law of the land applies equally to all unless there can be an objective differentiation. Fifth, the law must give adequate protection of fundamental human rights. Sixth principle, means must be provided for resolving disputes without prohibitive cost or delay. Means must be provided for resolving disputes. Means must be provided for resolving disputes without prohibitive cost or delay. Seventh principle, ministers and public officers must exercise their powers in good faith for the purposes and without exceeding the limits of those powers, for the purposes and without exceeding the limits of those powers. The eighth principle is that adjudicative procedures provided by the state should be fair. And lastly, the rule of law requires that the state complies with its obligations in international law. So that's the first section about the rule of law. The second section just sets out a few fundamental rights that have been established by Parliament or recognised by the courts. So the first one is the right to trial by jury. We've talked about that before. The second one is that no person may be imprisoned without lawful judgment. The third is that there should be no excessive bail, B-A-I-L, bail meaning caution. No excessive fines, and no cruel or unusual punishments. Fourth, the legality of detention can be reviewed at any time by the court. That is of course, the principle of the habeas corpus writ. Habeas corpus writ, which enables a friend, a member of the family, to apply to the court to have the detention of a person reviewed if the person himself or herself cannot, for any reason, make the application to the court. And the jailer or the person detaining the person is obliged to bring the detained person to the court. And in 1679, the Habeas Corpus Act established heavy penalties for prison authorities or others who failed to bring prisoners to the court within a reasonable time. And I think I've mentioned the case of A and others against the Home Secretary in 2004. Does that ring a bell? A and others versus the Home Secretary. Persons suspected of terrorist activities who were also illegal immigrants who could be detained indefinitely without charge under anti-terrorist legislation. This was held to be contrary to the European Convention and probably contrary to common law as well. Fifth, freedom from torture. There's a case called R versus Felton, F-E-L-T-O-N, of 1628. Felton, F-E-L-T-O-N, 1628, which decided that evidence which had been obtained under torture could not be used in the English courts. Next is the protection of privacy and property. And this was restated in a case called Entick, E-N-T-I-C-K, Entick versus Carrington, C-A-R-R-I-N-G-T-O-N, Carrington, C-A-R-R-I-N-G-T-O-N, Entick, E-N-T-I-C-K, of 1765, where it was held that a royal warrant, just trying to remember what it is in French now, mandat de perquisition ou d'arrestation. A royal warrant to seize the books and papers of a member of the House of Commons was illegal, and that any attempt to carry out the warrant would constitute a trespass. So the right of the police or anyone else to come onto your property to arrest you or to seize your property or evidence is strictly controlled by legislation. Taxation, we've already said, but I'll just mention it again, that only Parliament can decide taxation. And the principle was established in by at least, I should say, the Petition of Right in 1627. Petition of Right, 1627. So that when a minister decided to increase the television license a few years ago, the courts had to remind the minister that only Parliament could decide that, and not the minister. Last on this, just to mention the Human Rights Act, because the Human Rights Act of 1998 established in our internal law the principles of the European Convention. And under that legislation, the principle of proportionality has developed. And we'll talk about that when we look at the question of enforcement. I think we've just got time to start the subject of enforcement, so you've got the background, and we'll finish that in the next session, because I don't think we'll quite finish it today. But at least you'll have got the basic idea. So a new section which I call Enforcement of Constitutional Rights. And the first point is that the control of authority developed out of special procedures of the common law. Through a system called prerogative writs, which we now call judicial review. So the procedure for judicial review is organized under the rules of the senior courts, and applications for review are usually heard in the administrative court. Which is located where? Have you got your table in front of you? The table we distributed. You should have it in your pockets all the time. You should be looking at that every morning when you have breakfast. Okay, so it's in the High Court of Justice, Queen's Bench Division. That's the sort of thing you're going to get in the QCM. So, the cases for judicial review are brought in the name of Regina, the Queen, Regina. And the name of the applicant is put in brackets after the name of the Queen, and then it's against whatever authority is whose decision is being challenged. The judicial review remedies are as follows. Firstly, a mandatory order, which is an order to an authority to carry out its functions. For example, an order to a police authority to maintain law and order. The second remedy is a prohibiting order, which is designed to prohibit an authority from exceeding or misusing its power. Or preventing it from using a power it doesn't have. The third, the third type of order is, or remedy, is the quashing order, Q-U-A-S-H, quashing order. And that quashing order will usually remit the matter to the decision maker to come to a new decision, or direct the authority to reconsider the matter. The fourth type of remedy is injunction. So you remember, in facta tame, the court injuncted the government, prevented the government from enforcing legislation that was contrary to European law. That might include, and there's quite a well-known case called Re M, which concerned an immigrant from Zaire who was the subject of an expulsion order, and the court asked the minister to keep Mr. M in the United Kingdom for a further 24 hours to enable the court to reach a decision. And there was a mix-up in the Home Office, and Mr. M was actually deported to Zaire overnight. So when the case came back to the court the next day, his lawyer said, well, unfortunately, he's gone. And on Mr. M's behalf, his lawyer then started injunction proceedings against the Crown, against the minister, on the basis that the minister had actually committed a contempt of court for not obeying the judge's order. And the court decided that a minister would not be exempt from contempt of court proceedings, which meant that the minister could, in theory, be sent to prison or ordered to pay a fine. But the court said, we have received a letter of apology from the Home Secretary, and in the circumstances, we won't impose any penalty. The fifth type of order is a declaratory order. A declaratory order just means that the court will is being asked to declare what the law is. And the tradition is that the governments and authorities will actually perform the law as declared by the court. And the last type of order is an order for damages. So those are the various types of remedy that the administrative court can grant on a judicial review application. The next section will deal with the grounds for review. So maybe very quickly I can just set out the headings and then we can come back on the detail next time. First of all, illegality. That means the lack of legal power or jurisdiction. So, grounds for the review. First is illegality, lack of power, lack of legal power or jurisdiction, lack of evidence to back up a decision, errors of law. An example of that was a case called the HM Treasury versus Ahmed, AHMED, which was a Supreme Court case in 2010, where the Supreme Court held that the secondary legislation enabling the government to freeze assets of suspected members of Al-Qaeda was illegal because it had gone beyond the powers that had been granted by the United Nations Act of 1946. So I think you call that the contrôle de légalité. The second ground for review is the abuse of discretionary powers. And the courts had established in the 1960s, I think, 1960s, what were called the Wednesbury Principles. Wednesbury, not Wednesday, but Wednesbury, W-E-D-N-E-S-B-U-R-Y, Wednesbury Principles, which meant that decisions had to be reasonable and rational. And the principle of proportionality has been added to that following the Human Rights Act and Strasbourg case law, and principles of proportionality in European law. There was a case this year called PHAM, P-H-A-M, versus Secretary of State for the Home Department, which was all about a person who was suspected of terrorist activity and had his British nationality withdrawn. I think we'll stop there because it's almost 10:02. We've got a little bit more to do, but it won't take very long. which we'll do on the 23rd. I'm just crossing my fingers that the slot that they give us will be convenient for you, because apparently we're not going to get the lunchtime slot. So once we know what that slot is, if that poses an insuperable difficulty to the majority, please let Mrs. Condis know. We'll see if we can find another date or time that fits. Unfortunately, as you know, we don't always have a great deal of flexibility with these things. Whatever happens, I will distribute a note just to help. You've probably noticed that I've sort of been reading, but not really today. I've been sort of extracting bits out of the note. I'm just trying to give you what you need, really, the essentials. So if I distribute a note, it may be a bit more detailed than what you've actually written down today, possibly not in the same order, because I'm incapable of staying to any strict order. Every year I rewrite these things and I think, why did I put it in that order last year? And I'll probably do the same again next year.